Fabulous. Right, Amy, would you like to give us a little introduction on who you are and where you're from? And then
I would love to.
Presentation.
Thank you very much. Thanks for having me. So my name's Amy Surgerson and I'm soon to be a partner at Muckle LLP, and I'm in the employment and business immigration team. So we do lots of work in Cumbria with Cumbrian organisations, and we've been asked for a lot of support recently on understanding business immigration, how you can all work to support workers to come to the UK or to remain and work with you, and particularly looking at skills shortages that a lot of you are experiencing. So Eve has asked me to pull some notes together. So can everyone hear me okay? Is that okay? Can you hear me?
So, yeah, yeah.
So yes, the session this morning is just to give you an overview really of the current immigration regime and some options that you might have to understand how you can work with individuals, including the employee sponsorship route. We're going to spend some time looking at the sponsorship route in particular and how that works in practice, because I know lots of organisations now that COVID seems to be, for the time being, disappearing a little bit and becoming less of a worry, are now starting to think about future plannings and what you need to do and your recruitment needs. So sponsorship is kind of higher up many more agendas. So we'll have a think about that. And also we're going to have a look at right to work checks, because there are some important changes coming next month that all of you will need to be aware of and implementing within your organisation. So it's helpful just to bring you up to speed with that. And as Eve said, we've got a chat function. So if you want to raise questions during that as we go through, as the topic arises, that's absolutely fine. I'll make sure that that's non-attributable. So I won't name and shame. But if you'd rather wait until we stop the recording at the end, that's absolutely fine. We can pick that up at that point. And if it's easier to pick up separately, then we can always pick up after the session as well. So thank you very much, Eve.
Great. Can everyone see these slides?
I can.
Great. Okay, I'm going to
good.
Yes.
Thank you, Lindsay.
And I'm thinking people are popping in the chat going, yes, 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 yes. Fabulous. Thank you, everyone. I appreciate that. Great. Okay, I will just go when you say.
Fabulous. So that's me. That's my mugshot, and you can follow me on Twitter, and you've got my contact details there if there's anything after the event that you think about. I'm sure we can share the slides with you as well if they're useful for you to refer back to, but do feel free to get in touch if there's anything further. So I think we're all muted on entry, as I was, which gave even I momentary panic when nobody could hear me when we first logged in. But yes, as I mentioned, if you want to raise any questions, just do so in the chat function, and we can take questions throughout, or we can take them at the end if you want, or pick up afterwards if you'd rather. Thanks, Eve. So the reason why this has become much higher up the agenda is because for business immigration law in particular, we've had huge amounts of change over the past couple of years, and this change isn't slowing down. So I started preparing these slides last week, and I sent them over to Eve yesterday, and then I realised something had changed since I drafted the slides and I had to redo them. So it's a really fast-paced moving area of law, and it's really important to keep up to speed with that because it impacts upon all of your employees and your organisation. So from autumn 2020, if we can hark back to those good old days when we were all in lockdown, we had a lot of changes announced to the immigration rules. And from December 2020, we had a total overhaul of the regime that we've got in place. So in the UK, since 2008, we've had a points-based system, which is similar to the Australian points-based system that they have over there. And effectively, the government rebadged the routes that we've got and changed them. A lot of them are really similar to what we already had, but some of the rules relating to those have changed slightly. And the government's mission at that point and their commitment is still to making sure that we're attracting the brightest and the best people to come and work to the UK. So they're trying to make it easier for those highly skilled, highly talented people to come to the UK, but they're making it trickier for low skilled workers, or those who are not considered to be suitably skilled enough to come and work in the UK, which has led to contributed to a lot of the skills shortages that lots of you are experiencing, and that's happening kind of countrywide. There's also a big push to change the actual process to apply to become a sponsor and to be monitored as a sponsor. So the government are trying to push towards digitisation, modernisation, linking up, which would be amazing and groundbreaking, linking up to other organisations such as HMRC records. So if you are a sponsor, it's very easy then for the government to, or the Home Office, to look through any application that you've got and link that into other existing information, rather than us having to go through what is quite a cumbersome process at the minute, for example, to become a licensed sponsor. So there are things which are going to be coming there. But what is a really fundamental change to what we've got now is that from the end of December 2020, we had the end of the free movement of workers from the EU, and we'll come on to look at that shortly. So that has absolutely mammoth ramifications for employers in the UK. So you're now not able to engage with workers from within the EU unless they can evidence that they have got the right to work. So if we could just move on one slide, please, Eve. Thank you very much. So the maps here that we've got, the map on the left shows what we had prior to the 31st of December 2020. So all of these countries here, we've got the European Economic Area countries, which was 27 when we were in there, now 26. And we've also got Iceland, Liechtenstein, which I can never spell correctly, Norway and Switzerland. And all of those workers from those countries could come and live and work prior to the 31st of December without any restriction. We didn't have to worry about anything. We could take a copy of their passport, copy of residence cards, and we were able to employ them without having to give it a second thought. But from the 31st of December 2020, that all changed. So now when somebody entered the UK after the 31st of December, unless they are a UK national or an Irish national, the map that we've got here on the right, you need to think a little bit differently about whether or not that individual does have the right to work in the UK. So the countries on the left, clearly it's absolutely mammoth. That's a huge talent pool now that we can't just as easily tap into. So just from the European Economic Area countries alone, it's estimated that that's over 450 million people who would otherwise just have been able to pop across, come and work with us. That's not even counting the additional 4 countries. And now they can't do that. So it's had a huge and immediate impact on so many sectors and so many organisations. And it just means that we need to think a little bit more creatively about how we can work with those individuals. So Ireland, although Ireland's not in the UK, we have got reciprocal arrangements with Ireland. They can come, Irish workers can come and work in England and Wales and Scotland, and likewise we can go to Ireland as well. So an Irish passport is usually all that we need to see, and similarly with Guernsey and Jersey. Thanks, Eve. So this might be a familiar image to some of you who supported your employees who were EU workers. And when I refer to EU workers, I'm talking about those workers who've come from the European Economic Area and those 4 other countries that I mentioned. So this was a transitional arrangement that we had in place for those individuals who had arrived or were living in the UK prior to the 31st of December 2020. So if they were in the UK prior to the 31st of December 2020, they could apply to what is called the EU settlement scheme for either settled status if they'd lived here for 5 years or more, or pre-settled status if they'd lived here for less than 5 years. And the pre-settled status route is effectively a time-limited visa. So they get a period, however long they've been in the country, counts towards that 5 years, but then they would need to extend their pre-settled status and eventually apply for settled status when they get to that 5-year trigger point. So lots of you might already have been working with to support your employees to apply for this. So if they weren't in the UK prior to the 31st of December 2020, from the 1st of January, they needed to have some other kind of immigration permission and be able to demonstrate that to have that right to work. So that was a really big shift and a really big change. And I think it's quite interesting to understand some of the statistics behind this, because obviously there were so many EU workers in the UK, but not everybody chose to apply to the EU settlement scheme, which is actually absolutely their prerogative. Employers did an awful lot to try and support and raise awareness around this. But the statistics to the closure of the EU settlement scheme, or what should have been the closure, to the 30th of June 2021, was that 6.1 million applicants had applied, which doesn't feel like a huge number really, does it? But 8% of those were repeat applicants. So there are strict rules around criminal
allegations and any issues around criminality, and there were lots and lots of applications that were refused on that basis, and because the applications weren't filled in correctly. So actually from that 6.1, only 4.9 million were actually granted out of everybody who could have applied to that scheme. So it wasn't quite as widespread as it could have been, but there are only 4.9 million people who have currently got access to the EU settlement scheme and can evidence their right to work this way. So there was a lot of concern at the time about what if somebody wasn't aware of the EU settlement scheme. This is something which has been pushed for over 18 months before the closure of the EU settlement scheme. So it feels unlikely, but there were still people for various reasons who couldn't apply. And so the Home Office made some concessions to allow people who couldn't get the application in time to pop in a late application for consideration. But their parameters in terms of what is acceptable and what is considered were and continue to be very restrictive. So it is still possible for someone to put in a late application, but they must have such compelling reasons, such as complete physical or mental incapacity, domestic violence, children in care, an abusive or controlling relationship, that kind of thing. So it's really restrictive. And while individuals might still be putting applications in, it's not, they aren't necessarily going to get that through. But while that application is in for consideration, they can still continue working for you. And that wasn't the case as things originally stood last June, but that is something which has since been updated. So if someone puts in an application to the EU settlement scheme, they can work for you until the application is concluded. So just to summarise what you need to think about then for your EU workers. So yes, they can continue to work for you, but you need to look at how they are able to do that. So they can evidence that by either demonstrating that they have got pre-settled or settled status under the EU settlement scheme or some other immigration route. And we'll come on now, Eve, if we could just switch slides, please, to look at what some of those other routes might be. So there are different ways in which you can employ people and so many different visas, which are always being overhauled. And I'm not going to have the opportunity to talk you through all of them, but we'll look at some of the key options that you might have at the moment, and anything else that you can think of, happy to have a chat about. But for the first section, I just wanted to have a look at some visas and some routes that are open to individuals. So these don't require sponsorship, they don't require the employer to do anything, but subject to an individual's own circumstances, they might actually be able to evidence they have a right to work or get their own immigration permission based on their own personal circumstances or their family's circumstances, which obviously can save a lot of hassle if it means that you as an employer don't need to then sponsor them to work in the UK. Thanks, Eve. Just the next slide, please. So some of the routes that we've got, the first one is global talent. And for any of you who are familiar with the scheme that we did have in place prior to December 2020, this is effectively our tier 1 exceptional talent route, which has just been rebadged and changed slightly. So this route is aimed at those leaders of the future in science, humanities, engineering, arts and digital technology. And applicants must be endorsed by a recognised UK body in order and approved by the Home Office. This body must be approved by the Home Office before they can apply for their visa. So the British Academy for Humanities, the Royal Academy of Engineering is recognised, Technation is recognised for digital technology, Arts Council England is recognised for art and culture. And there's also a fast track route for technology, engineering and mathematics. And for any of you who might want to employ Beyonce, if we have any holders of certain prestigious awards, so we've got Academy Awards, BAFTAs, Brit Awards, Golden Globes and Grammys and Nobel Prizes, people who have that kind of prize can apply on their own volition, on their own basis to live and work in the UK, and they can proceed to settlement fairly quickly after 3 years. So it's probably not an option for most of us, but if Renée Zellweger were to want to come and be employed by you, then that might be a route for her to think about, and it would mean that you wouldn't need to offer her sponsorship for that. Then we've got startups and innovators, which are fairly similar. So this is designed for entrepreneurial talent and attracting that entrepreneurial talent to the UK. And for those individuals who've got innovative and scalable business ideas within the UK. So for the innovator route, they have to show that they have sufficient funds to make that
potential innovative business idea take off. It used to be until very recently that they had to show they had £50,000 as a minimum, but that has now changed and is now sufficient or adequate funds. So this route, the business itself must be viable and scalable, and again, must be endorsed by a recognised endorsement body to show that it is that, or that it has got some grounds and some potential merit there. So those are probably a bit more nebulous and something that we wouldn't necessarily ordinarily always think about, but subject to an individual's circumstances, it could be that they've got UK ancestral rights. So if you have an individual who wants to work for you and they're a Commonwealth citizen and they've got a UK born grandparent, they can come and work in the UK using their ancestral rights. And after 5 years, they can do any kind of work and they can settle, and they can even do self-employment, which is quite rare for a lot of these routes. Self-employment isn't always easy to come to the UK to do at the moment. So they can come to the UK and permanently settle here after 5 years. So that's just why it's worth asking questions about any prospective employee who might be coming from overseas about their own background, because it might be that this is an option that they haven't thought about. But another potential route which can be really useful, and I know lots of organisations do use this, are students. So these are students who are sponsored by their own educational establishment, their university, their independent school. They can do work for you, and they can work during term time, although it's restricted to 20 hours per week. But during vacation time, they can work without any restrictions and no limitations. So they can work full time for you during vacation time. But what is really important to think about is that you need to be very careful as an employer not to inadvertently breach the terms of those visa restrictions. So they are very strict. They can only do up to 20 hours of work during term time. And what you need to do when you recruit anyone who is an overseas student who's been sponsored in the UK by their educational establishment is, when you do your right to work checks, also take printouts from their university or their college or wherever they're studying, which evidence what their term dates are. So then you can clearly and easily marry up when you look at timesheets or however else you would record the work that they do, that they haven't breached those restrictions. Just if you were ever challenged or they are ever challenged, it's much easier then to just demonstrate we've done this and keep a copy of those term dates with that right to work information so that that is evident and available. And that can be really useful. It's a good opportunity to try those students out before you might then look to sponsor them after they graduate. And the post-study work visa, now called the graduate visa, is also a really useful route. And that's one that just reopened in the summer of last year. So we did have something similar that was abolished under Theresa May's government, which was the post-study work visa. But for anybody who graduates, they are able, from a UK university where they were sponsored, they are able to remain in the UK for 2 years if they do a master's or a bachelor's degree, or for a PhD, it's 3 years. And they can live and work without any restriction. They don't have to be paid a special rate of pay. They don't have to do a suitably skilled job. And so you've then got potentially a 2-year trial period where you can effectively try before you buy, if you wanted to potentially sponsor somebody and this was an option, which can be really useful. And lots of organisations are now starting to use this, and it's been really helpful to them. But equally, because we don't have this requirement that the worker is suitably skilled, it gives businesses and organisations flexibility to employ people this way when their role is deemed not to be suitably skilled. So those lower skilled workers, because there's no restrictions on that. So if you are an organisation that has more of a transitory workforce, for example, this might be a good opportunity for you to fill some of your skill shortage using graduates on a temporary basis. We've also got the Youth Mobility Scheme, which I haven't put on the slides here, but this is for anyone who's 18 to 30 from certain countries like Australia, Canada, Hong Kong, Japan, San Marino, Taiwan, and those young people can come to live and work in the UK for up to 2 years. And that, again, could be an option for some of your overseas workers, so something to think about and explore. But some new routes which are coming from spring 2022, and we don't have a huge amount of information about them, even though we're pretty much in spring 2022. But the first one, which could be a good option, is the high potential individual. And again, this is a hark back to the tier 1 general route that we did have that was abolished in 2015. So those highly skilled migrants. And the idea is that this is going to be open to those individuals who are deemed to be academically elite. So there's going to be a list, we believe, of endorsed universities, top global universities, and they're an individual who doesn't need to have a job offer, doesn't need to be sponsored, can come to the UK if they can show that their salary or potential earning power is enough, if they score highly for age, so the younger the better, or that's how it was under the old regime, salary, and their postgraduate qualifications are all relevant. So for the best and the brightest who are academically elite, this could be an option for them. And it would be a personal visa to that individual, which would mean it's portable. So all they'd need to show if they were coming to work for you is that they had the right to work. You wouldn't need to sponsor them. The fact that they would have this visa is enough and would tick the box to give them the right to work. We're also going to have some big changes to global mobility. So at the moment, we've got an intra-company transfer route where you can sponsor somebody if you're a global business and move them using that route to come and work in the UK. But the problem with that is that it's fairly cumbersome, it's fairly clunky, it's not aligned to the sponsorship regime that we've got. So the salary requirements are significantly higher for the intra-company transfer versus the straightforward sponsorship. And it can be a bit tricky. So the Migration Advisory Committee have been pushing for a long time for this regime to be overhauled and re-looked at. And so we've got something now coming, we believe, in the global business mobility route. So the idea is that this is going to allow innovative overseas businesses greater flexibility to move their workers around and also to establish businesses and subsidiaries within the UK. So this is going to allow also for intra-company transfers rather than the sponsorship route that we currently have, and hopefully enable some workers to come to the UK to undertake a secondment or a short assignment, because it sounds fairly straightforward, but actually it's really tricky to find a route always to get somebody to come over to do that on a short-term basis. If you want them to actually do work, it can be a bit difficult to do that. So hopefully that's going to really help businesses, and that is something which is probably one to watch from kind of April, May time. And then we've also got the scale-up route. So that is going to make it easier for companies around the world who are experiencing rapid growth to employ the best skilled work from around the world. So they would need to have a job offer, but don't need to be sponsored. The minimum salary, we understand, is going to be £33,000. And to qualify as a scale-up, the business must have a minimum of 10 employees at the start of a 3-year period, and then have at least 20% growth during that time as well. So that's a big change to think about there. But what you can't see on here is what we can do for low skilled workers. And I know Eve and Rich, who's not able to join us today, have talked a lot about how this is impacting upon so many organisations, particularly in Cumbria, because we don't have that route to be able to sponsor an individual who's not considered to be at a suitably skilled level. So we've got certain temporary routes, which I'm sure you've all heard about. So we can bring people over on a temporary basis to pick fruit of veg, for example, to be poultry workers, although that route closed on the 31st of December. We could do the same for pork butchery, but that closed. HGV drivers, there was a temporary route there, but there's nothing permanent or on an ongoing basis. So I think a plea from us and from Eve and Rich would be, if you are a business that is experiencing a shortage of work, or you can't fill the vacancy and you think that immigration is the blocker, shout about it, talk to us, talk to Eve, talk to Rich, so that we can make noise about it, because noise can bring change if it's exercised in the right way. It brought the temporary visas that we had at Christmas time, but things are changing. And the Migration Advisory Committee is pushing for changes. So if you've got evidence where you've not been able to fill a vacancy, please do share it. And that will only help to inform policy going forward. So it's worth thinking about that. There's also another route, which is dependence. So if you've got somebody who has a family member over here, it might be they can latch on to their family member's visa. And again, that would mean they wouldn't then need to be sponsored or have another way to remain in the UK, which can be quite a helpful route. But I know we've already had lots of questions this week at Muckle about what we can do to support those workers from Ukraine. And Eve and I were talking about this over the past couple of days, because obviously lots of organisations are now desperately trying to help anyone that they can do to get out of Ukraine and get over here. But unfortunately, at the moment, the UK haven't followed suit with the EU. And so we do have a fairly restrictive regime in place to support anyone who might be trying to leave the Ukraine. I say that as of today's date, the 2nd of March 2022, but that can always change and might change over the next couple of days, so is one to watch. But at the moment, only family members of settled Ukrainians can come and live and work in the UK immediately. So there's a 24-hour decision-making period for that, so it's quick. But by family members, we are talking about a spouse, an unmarried partner, providing they've been living with them for more than 2 years, a parent if the settled person is under 18, or if you are supporting a parent or an adult who lives with you who is ill, then they might be able to come over too. But at the moment, it's that restrictive. It doesn't go any further or any wider than that. But for Ukrainians who are already in the UK, there are some temporary concessions. So if a Ukrainian is here on the basis of a poultry worker or HGV or seasonal worker, they can apply for an extension to the end of December this year to remain in the UK. If they are a skilled worker or a student, again, they would usually need to leave the UK and reapply from externally, but they can apply on compassionate grounds to have that application considered in country and quickly, so they don't necessarily need to leave and make that application. So that's one thing to think about if you are supporting individuals who are from Ukraine or worried about being there or going back. Thanks, Eve. So that covers off what I wanted to talk about in terms of routes for employees personally. And if there are any questions, feel free to pop them in the chat. Now let's have a look at sponsoring skilled workers. And I know some of you already have sponsor licenses, but I think it's helpful to take you through the process that you need to go through and some considerations that you would need to have as a licensed sponsor. So as I mentioned, the whole premise of government policy on immigration to date has been to make it a long-term solution to bring up the brightest and the best over to the UK. They want to make that easier, but they have been resolute that there's not going to be a long-term solution for companies who are wanting to bring in low-skilled workers. So that does give us much more limited options in terms of supporting those individuals who aren't considered to be suitably skilled enough. So we've talked about those temporary routes that we might have, but if we can't think of any other way that we can support an individual, then it might be that sponsorship is the main route. And for lots of employees now coming to the UK or wanting to move from employer to other organisations, they expect to be sponsored because it's kind of par for the course now, because there are so many more individuals following the end of the free movement of workers who need to have some support to remain in the UK. So let's move on to the next slide, please. Thank you. So the process itself to become a licensed sponsor, there are dozens of guidance notes. Some of them are 70 plus pages long. There are appendices. It looks incredibly complicated and it is cumbersome and it is clunky and it's an area of review for the government. But at the moment, what we need to do is pull together a sponsor license application. And the application itself isn't particularly complicated. If you've got all of the information together, you could sit down and you can do it in 20 minutes to half an hour. It's straightforward. But the devil is in the detail with the documents that you need to provide to support that application. And what the Home Office is trying to find out is to make sure that you are a genuine business within the UK, that you can maintain your sponsorship obligations and understand what they are. And they will come, they can come and they can inspect, they can ask questions just to make sure that that is the case. But how you demonstrate you are a genuine business is by the supporting documents that you provide. And there are some sectors where there are specific documents that you need to provide. For example, if you're CQC regulated, you need to provide evidence of those numbers and those documents. And if you have to provide company accounts because of the size of your company, that is one document which you must provide or must signpost them to on Companies House. But there are a minimum usually of 4 documents that you need to provide. But I would always say get in at least 5 if you can. The more the better. But these are things like evidence of your employee liability insurance cover of up to £5 million, HMRC numbers, VAT registration numbers, and they all go and are bundled up and sent over to the Home Office. You've got 5 days to provide that supporting documentation after you complete the sponsor license application. But my advice is always, always, always do it at the same time. The documents are where you need to put your focus. So get those done before you do that license, because there is nothing worse than not being able to do that because your application will be battered back. And the document itself, because quite often we're beholden to other organisations. So it might be that you need bank statements, you need evidence from HMRC, you might need a letter from your bank to support the application. And that takes time. That doesn't happen quickly. So for all you think, okay, I can quite easily get these 4 or 5 documents, usually it can take a couple of weeks. So that is a time factor which you need to bear in mind at the start of the process and get that right. And then once you've done a fabulous job and checked that your documents are in line with the immigration rules, and they are incredibly prescriptive, so read those with a very fine-tooth comb, because if there's any deviation or issue with those, the application won't be successful, or you'll be asked to provide further copies of the documents. Then you must also pay a fee to become a licensed sponsor. And the fees at the moment are £536 if you're a small or charitable organisation. And by small, we're talking about the Companies Act definition. So that is less than 50 employees and a turnover of less than £10.2 million. If you are medium or a large organisation, it's £1,476 at the moment. But again, those fees are likely to go up. And then we must apply for a certificate of sponsorship. So a certificate of sponsorship is, it gives you effectively a PIN number, so just a code that you would then pass on to the prospective employee that you want to engage, and they put that on their own application to become a sponsored skilled worker. So when you are applying to become a licensed sponsor, if you haven't already, you can ask for a number of undefined certificates of sponsorship. And undefined certificates of sponsorship is what we did have when they were called unrestricted. So undefined is for those individuals who are already in the UK. So it might be that you have students who are going to graduate soon that you might want to sponsor. It might be that you've identified some people who are working for competitors or other organisations, or they're relocating and want to come to work for you. Then you would look at those undefined certificates, and you can get those as a block with your license. And the benefit in applying to have that is that once you've got those in the bank, you then can skip a step when you are looking to assign that certificate because you've already got them. If you are looking to recruit somebody from outside of the UK, then you need to have a defined certificate of sponsorship. And this is similar to the restricted certificates that we used to have before they were overhauled. We used to have a cap on the number of certificates that we could offer to those individuals outside of the UK. You used to have to get the applications in by a certain date in the month for them to be considered. That has all gone. But what you need to be able to show now is that you have a genuine need to fill this role. So you can't have created a role to facilitate immigration. You must have a role that exists. So you need to be able to demonstrate this by things like your job descriptions, interview notes, recruitment process, to evidence that the person you have identified from outside of the UK is the best person for the role. And you would then be looking to assign them a defined certificate of sponsorship. And the process to assign them or to request one is different, because you have to have somebody in mind for that job, and you have to give details of who that person is and what their passport number is and that kind of thing. So that has to be specific to them. And an important change to the system that we've got now is that we no longer have that resident labour market test, which some of you may be familiar with, where we had to advertise a role for a minimum of 28 days in at least 2 places, and one of them had to be on the Job Centre web page, which inadvertently meant that organisations were completely strewn under with masses and masses of applications from individuals who weren't capable of doing the job. But it was a real faff, and it took a long time. It took an extra month in the whole process before you could get to offering sponsorship. That has now gone. So rather than that, you just need to be able to demonstrate that requirement to have the role, and the fact that you've gone through a process and the person you wanted to employ is the most suitable. So hopefully that's fairly straightforward. And you will either have a bank of certificates, of undefined certificates attached to your license, or you can request those after the event if you don't have any. And you can also request those defined certificates if you're wanting to sponsor people from outside of the UK, but you must have a person in mind in order to be able to justify that request. Then once you've done that hard work, the easier part in theory is to assign that certificate of sponsorship to somebody who's considered to be suitably skilled. And I've talked a little bit this morning about suitably skilled. This is an area, again, which was overhauled in December 2020. So suitably skilled used to mean those individuals who were considered to work at a level of RQF level 6, which is effectively degree level. This was brought down to RQF level 3 in December 2020, which is effectively A-level skills. So that individual must have those suitable skills and they must be paid at an appropriate market rate. And that is stipulated in Appendix Skilled Occupations to the immigration rules. So there are specified salary bands and you mustn't go below those. And if you do, you can't sponsor that individual. So it's always worth looking at that to make sure that your proposals will be within the parameters. But one big change that we had just a couple of weeks ago from the 15th of February relates to care workers. And I know we've got a couple of individuals who've dialed in today from the care sector. So if you are an employer who is in the regulated sector providing adult social health care, then there are a change now from the 15th of February where you can offer care workers, care assistants and home care workers, subject to certain other requirements, sponsorship. And this is a massive deviation because these roles have traditionally not been considered to be suitably skilled enough, which feels absolutely preposterous considering what we've been through over the past couple of years, but they haven't ticked the box to be considered suitably skilled enough to attract sponsorship. But these roles are now on the shortage occupation list, which recognises the fact that organisations in the care sector are massively struggling to fill these vacancies. So provided they are paid at a certain rate and tick other boxes in terms of attributes, then it is now possible to sponsor care assistants, care workers and home care workers using this route. And this is a temporary concession for 12 months. So our understanding is that the visa will still be valid for the full 5 years, but the process of being able to do this will be reviewed after 12 months to see if it works, see if it's required. So if you are in the care sector and thinking about this, now is the time to start thinking about applying to become a sponsor or to look into to utilise this while it's available. So when you assign the certificate of sponsorship, you need to have identified the migrant that you want to assign it to. You populate their details into a system, and all of this is done online on what's called the sponsorship management system, which some of you might be familiar with. It's supposed to be fairly user-friendly. It quite often crashes, and there is a helpline which we frequently make calls to try and get some support with to manage as we're going through. So you assign that certificate of sponsorship and you have to pay a fee, and the fee is £199 just to assign that certificate of sponsorship. But there's also a big clincher, which has put many organisations off this whole process for quite some time. And this is called the immigration skills charge. So this is a fee that you must pay before you can go any further in the process in order to be able to sponsor the individual. And there are certain exceptions. So if you have a student who's sponsored as a student or a tier 4 under the old regime, and they then come to work for you, you don't need to pay that immigration skills charge. Currently, the changes to the care sector rules around care assistants are exempt from the immigration skills charge. So that's great and really helpful. But ordinarily, the cost is for large employers £1,000 for the first year of the visa and £500 thereafter. It's slightly lower, it's £364 for small or medium employers for the first year and £182 for each 6 months thereafter. So if you're thinking about assigning a 5-year visa, then as a large employer, that's an additional £5,000 cost that you pay immediately on the company credit card before you can get any further in this process. If you're a small or a medium employer, that's £1,820 again that you need to pay immediately and stump up before you can continue through the process. And there's no anti-avoidance option either. So you couldn't just offer somebody a visa for, say, a year or 2 years and then hope to get by that immigration skills charge and extend the visa later down the line. That immigration skills charge still bites and is still payable for the duration of that 5 years. But after that time, there might be some exceptions and you wouldn't need to pay it for any renewal. So that's a big fiscal outlay that lots of organisations are worried about and has, I think, put some people off going down this road so far. So then once you've put that money on the company credit card and you've assigned that certificate of sponsorship, it will formally be assigned to the individual that you've put the details on, and they'll be given that number that I talked about, that effectively PIN number. They then make their own application to become a skilled worker, and they would pay their own fee, which ranges from £600 to about £1,400, and also pay the immigration, so the immigration NHS health surcharge, which at the moment is £624 per year. Some organisations like to help their prospective employees out with those costs, others don't. That there's no right or wrong, it entirely depends on what you want to do, but it's always helpful to make sure that if you do intend to support, that you have some kind of contractual right to claw back any costs that you might put out there if the individual doesn't come back, doesn't work for you, or goes and often works for somebody else within a certain period and that kind of thing. So that's always worth thinking about. There are options because this is a points-based system, the individual scores points based on the fact that they have a job offer, which they must have. They must be working at the appropriate level. You can't deviate from that, but there are options to flex the salary a little bit if there are tradable points available. So there can be tradable points available if an individual has a PhD, for example, and this is a role which requires a PhD, which there aren't a huge number, and it's specified on the government website. And if that is the case, or if they're in shortage occupation, for example, there's flexibility about the salary to a certain level, but generally they do need to be paid at the requisite level in order for that to be considered. So there's quite a lot there that needs to happen, and it's probably worth giving you an overview. I'm sure many of you would ask, how long would all of this take? How soon can I start the process and then get somebody to work for me? And I think the first part, the supporting documents, it can take a while, as I mentioned, because you might be asking other organisations to support you, and you don't always necessarily appreciate that might delay things at the outset. So typically it can take 2 weeks to a month to ask other organisations for documents or to get things together in-house, or if you're asking different departments or different people within your own organisation for this information, if they're on holiday, for example, it always takes longer than you think. So there's that lead-in period where you're getting those documents together before you can actually do the application. And because we now don't have that resident labour market test, the government have made a big song and dance about the fact that we've saved 28 calendar days there in having to advertise, which is great, and it has made a big difference, and it does streamline the process. At the moment, the timescales for actual consideration of the sponsor's licence are said to be about 8 weeks. Recent applications that we've supported with have come back after about 4, but the Home Office can always ask you extra questions. They can come out and do on-spot inspections. And also we've now got the situation in Ukraine, which means that we are seeing a huge increase in the number of organisations who are trying to become licensed sponsors. So we've now got a bottleneck. So that 8 weeks might increase, but as a rule of thumb, the promise is that would be returned within 8 weeks, but it might not be. If you apply for undefined certificates of sponsorship when you get your license, that's great, because you've already got those sponsorship, those COSs in your pot when you want to then offer somebody employment and they are overseas workers already in the UK. But if you need to apply for defined COSs, then that is a whole separate process. And as I've mentioned, you need to be able to justify the fact you need this role and why you have to go to overseas workers rather than a settled worker. And also you have to have identified somebody who can do this role. So when you put the application together, it's fairly straightforward. You need some information, but it's doable. And it was said that the decision would be turned around within 1 working day. But our experience recently is that has been far exceeded in a bad way. So for many organisations, it's taken about 4 weeks now to get those defined COSs back. The Home Office are asking lots of questions, which is why it's always incredibly helpful when you're doing this application or this type of application to kind of tie everything up for them in a really nice ribbon, make it very clear what everything relates to and explain everything in lots of detail. I and my colleagues spend lots of time pulling together really detailed covering notes, for example, explaining exactly why we're looking for a licence, why we need defined COSs, who we're trying to recruit, just to make it really clear and hopefully push to limit any pushback, and that does really help. So always think about that. So you might be looking at an additional month at the moment for those defined COSs. If you've already got undefined COSs, that hopefully streamlines the process a little bit. But if not, then you would need to request those through the sponsor management system, and that again would take some time. Assigning the COS to the suitably skilled migrant is instant, so you can do that in one go. And as long as you can put the company credit card details in, then as soon as you've made that payment, you have assigned that COS. So there isn't really a big issue there. And then the worker makes their own application, and they hopefully will have all the information available to do that. And subject to the bottleneck at the time, that is a bit of an unknown in terms of how long that will take. Recently, it's been about 4 weeks, but I have heard some horror stories for individuals that have waited 18 weeks to get a response back on that. So you can see just from that timescale that you can't move quickly. Even with the best of intentions, it's really difficult to move quickly with this. What lots of organisations are starting to think about, and what we're supporting them to think about, is if you are now looking to the future, because we're all able to do that a little bit better for the most part, if you can see this recruitment need, if you think, actually, I've got a skills shortage here and I just can't fill it with settled workers within the UK, then it's worth thinking about, do I just apply to become a sponsor of skilled workers? You don't need to do anything particularly different. If you're not going to sponsor anyone, you've got to kind of obviously maintain your obligations, which we'll come on to look at, but you could already have that and shave off potentially 2 months of that whole process by having that in place and having individuals trained to run that. And then it just means you're kind of a little bit further forward. And we've had individuals recently in organisations who have lost out on really great talent because they haven't already had this license, and the skills shortage and demand and salaries going sky high. Individuals who had then gone to work for a competitor or somewhere else because they were going to have to wait to move. So it's really worth thinking about seriously if you see this might be a need for you going forward. Thanks, Eve. So if you are going to become a skilled worker, or if you already are, just a refresher on what you need to be thinking about. So if you're going to become a sponsor, then you need to make sure you've got key personnel to do key roles and maintain that sponsor obligations and make sure the license is kept up to date. So the roles that we've got are a key contact. So this is your main point of contact for all communication with UKVI, and that's generally your most senior person who's involved in recruitment, for example, in your organisation. You then need to have an authorised officer who is very senior as well, but is a competent person responsible for the actions of staff and people who are running the sponsor management system. They can be one and the same person, it doesn't matter, and you can add people or change them as you go through the process. This is just for the purposes of setting up the application, but you do need to have somebody to do each of these roles. For the purposes of making the application to become a licensed sponsor, you also need to have a level 1 user, and that is a person who is responsible for day-to-day management of the license. Unfortunately, when you put together the application itself, you can only name one person. And again, it might be that it makes sense for your organisation to have one person to fulfil all 3 roles, but just bear in mind, how would this work in practice if, for example, that person was off sick or was knocked over by a bus or went on holiday, and people weren't sure what the position was. So it's perhaps worth thinking about, if you can, having some variety there in terms of who does those key roles to make sure that they can keep up with the obligations. So you have obligations as a licensed sponsor, for example, reporting obligations. If you've got skilled workers who work for you, if their role changes, if their salary changes, if their role changes and you continue to employ them under the COS that they've got, although you are still sponsoring them, they are an illegal worker. You need to notify of that change of circumstance. If they move, if their hours change, if their salaries change, you need to notify UKVI of that change of circumstance as well. And also you need to make sure that your policies and procedures internally are up to scratch and really good. So right to work, which we'll come on to look at, you've got to do those properly. You've got to have that documented. You've got to have everybody who's doing that trained to give you that statutory excuse against negligently employing an illegal worker. Your onboarding processes must be right. And policies that you have in place for reporting worker absences, for example, where you have skilled workers, must be really tight and really hot. So you've got to make sure that all of those are done correctly and that all of your managers are trained, because you could be asked about that. And the risk in not having that in place is that could jeopardise the sponsor licence that you've got, and also jeopardise, therefore, the employment of anyone that might be attached to that sponsor licence. So you can either have your licence suspended or withdrawn completely, which could be catastrophic. And you can also have kind of a moratorium on any reapplication if that is removed. So it's so important to get that right. It's also worth bearing in mind that the Home Office, as I mentioned, can come and inspect at any time. So if you are thinking about becoming a licensed sponsor, get all of those documents and those processes sorted before you go down the road of making an application, because it would be horrendous to do so and then be unsuccessful because your right to work procedures weren't quite right, for example. But also, as I've alluded to already, think about the practicalities of how you manage these skilled workers and any migrant workers that you might have in general. So if you have got visas that are due to expire, you need to be all over that. You need to know when they are going to expire. You need to have that marked in appropriate people's calendars, and you need to be following up with your workers before they expire to make sure that they have got new immigration permission in place to take them forward. And you might need to support them with that or sponsor them potentially. So make sure that you've done that. Think about whether or not you've got enough people to do that as well. So think about if someone was off sick or on holiday, do we need to have this in a few people's calendars? If you are talking about key personnel for the sponsor license itself, then you might want to think about changing those to make sure that they are more appropriate. You can only have one key contact and one authorising officer, but you can have multiple level 1 users, and we've got a level 2 as well, which is a slightly different role. You can have multiple users for that as well. So it might be worth thinking about adding those people on. And again, horror stories from clients recently have been that when they've tried to add people on as level 1 users or change their authorising officer, they've been told there's a 15-week wait. So if, for example, you've only got one level 1 user who then puts in a notice, you're pretty stuffed. It's going to be pretty difficult for you to then move quickly. So think about having that variety and think about what could go wrong, as us lawyers always love to worry about. But also thinking about the contracts that you've got in place with your migrant workers, particularly where you're sponsoring them. For all of your workers, I would always advocate having in there a special warranty, which is effectively a promise that goes to the root of your contract to set out that they promise that they've got the right to work in the UK. And that is fundamental, goes to the root of the contract. If that turns out not to be correct, then that's grounds for termination and wrapping things up fairly quickly. So it's always worth having that in for absolutely everybody. Don't make assumptions based upon a passport that someone presents to you or what they look like or their surname, because that could pose a risk of discrimination. And there are British citizens who are presented as British citizens who aren't. We had a difficult situation with a client a number of years ago who had employed someone for 20 years, who then came forward to say, actually, you've been calling me Ian, but my name's actually Colin. And this is my uncle's national insurance number that you've been using and my brother's bank account, because I haven't been working here illegally, but I have now. So can you just call me by my right name and pay me into this bank account? Obviously, we couldn't and had to dismiss him. Bit of a nightmare, but that can happen. So don't make assumptions. Make sure you've got that contractual provision so you can deal quickly with anyone who is not here lawfully and treat that very seriously. But what's also worth thinking about, because we've looked at the fact that this can cost a lot of money to put in place to sponsor somebody, if you're going to contribute towards their fees or the immigration, the NHS health surcharge, for example, which is expensive if someone's moving over here, then you want to have the right to try and claw that back if they leave. So think about the way we would have in place if you were to pay for someone's training, for example, and then they leave within a specified period of time. You might want to have a sliding scale of a repayment structure in place and a separate agreement, which you can put in your contract or agree with them separately. So, for example, if they left within 6 months, 12 months, 2 years, you would have a reduced percentage clawback of those costs that you've incurred. And if they leave and you've stumped up that whacking great 5-year immigration skills charge of either £5,000 or £18,020, then again, you can claw some of that back from UKVI. So you don't necessarily need to worry about that. You can get that back. But for the other costs, think about having in place that kind of contractual arrangement to make sure that you can claw that back. Thanks, Eve. So unless you've got any questions on that, I'll move on to look at right to work checks. And just as a refresher, these checks must be completed before an employee starts work for you. So the induction is too late because they've already started. You must do this ideally during the final recruitment stages, taking copies of their relevant documents, and you have to obtain, check. We're not expected to be experts in understanding forgeries, but if someone has given you a passport and the blue tack to photograph over the top of it, which is a picture of them, then you might ask some questions about whether or not this is a genuine document. But otherwise, look at the documents, make sure you're comfortable that that person is who they say they are. If their name is different, for example, marry that up with other evidence. Have they got married? Have they got divorced? Is there a deed poll we can look at to marry all of that together? and make sure that you keep copies of those. And if you are doing manual right to work checks, it's really important that you physically write on that document or record somewhere online, I undertook this check on, and put the date on. So as daft as it sounds, if you just date that document, you don't have that statutory excuse against negligently employing an illegal worker. If you are employing an illegal worker and you don't know about it, the fact that you've done your right to work checks protects you. But if you haven't done those properly, then the risk is, if you're employing someone illegally, there's a fine of up to £20,000. There is also criminal sanctions. You can be imprisoned. Anyone personally involved in the recruitment process can be penalised. Directors can be struck off. Companies can have all sorts done to them. So it's so imperative to get this right, particularly now that we've ended the free movement of workers from the EU. There are so many more people who need to evidence that they've got immigration permission. You must do this properly, because this could be a big area of risk. So lots of you might have been doing COVID adjusted checks, for those of you who've been doing hybrid working or working from home during the lockdown. And this is something which came into place in March 2020, feels like a lifetime ago, doesn't it? So much has happened since. And that the date for those checks has been pushed back so many times. And this is one of the dates actually until last week. It was due to expire in April, but has now been pushed back to 30th of September 2022. So for your virtual COVID-19 adjusted checks, what you can do is, rather than having physical documents in front of you, you can have scanned copies emailed over to you or sent on a mobile app, and you then arrange a video call with an individual to check that those documents look right. And as long as you do that in line with prescribed documents, prescribed guidance, and as long as you have done that in line with the prescribed guidance throughout the whole duration of this temporary period, you don't then need to do any retrospective checks on anyone who might be working for you. Employers might choose to, and that's fine. But what you need to be very careful about is that you're not just picking out people who you think might not have the right to work because of their race, for example, because that is going to be discrimination. So we need to try and avoid that. But if you might want to ask all of your workforce who've joined over that period to provide evidence, for example, and that's fine. Just be mindful of that discrimination risk and do that carefully. So the idea to extending this is to enable, apparently, UK employers to get used to the digitisation of the process, which I'll come on to talk at with the new changes to digital right to work checks. So a question that we often get asked at this point is, what do we do if we don't do right to work checks? We haven't done them, we never have, or we're not sure how we should do them, or we've done them too late. Just rectify what you've done. So make a promise that from now on you will do it properly going forward. Happy to chat to anyone who's not sure and talk through what needs to be done. But equally, for those individuals who you have employed, the civil regime only came into the UK in 2008. So this £20,000 fine, which was £10,000 in 2008, only came in kind of 12 years ago. So if for anyone who was employed before that time, you wouldn't ordinarily have had to go through this process and get evidence of their right to work, but you might still choose to, which is fine and reasonable and sensible, so that you understand who you're employing and making sure that everyone has the right to work in the UK, and that's absolutely fine. But you don't need to do those retrospective checks for those COVID adjusted checks unless you want to. So some of you might also have been using what we've had for a little while as well, that Home Office online employer checking service to check whether or not somebody has the right to work in the UK. And it's absolutely brilliant. It's much easier. It means you don't have to faff around with original documents. You can do it all online. And what you must do is you would log into the employer section of the Home Office checking service. You can't take an email printout. That will not give you evidence or that statutory excuse against negligently employing somebody. So the individual that you are wanting to engage with, or your current employee, if they're already working for you, gives you their date of birth and a share code. And you plug that into the employer section of the employer checking service, and it will give you a lifetime evidence that that person has the right to work in the UK. You'll get a really high quality photograph of them as well, so you can easily check that that person is who they say that they are. And once you've got that, that in itself is gives you your statutory excuse. That shows you that they have got the right to work. As long as that comes back positively, you just keep a copy of that. So at the moment, that is for anyone who is applying under the points-based system or it has EU settled status. So effectively, it's anyone who's not UK or Irish, you can use that process for. And until the 5th of April, you can't force anyone to go down that road, which seems like a nonsense because from the 6th of April, you have to. But you can't force them to at the moment. So if they would rather give you manual documents, that is the check that you must do. But from the 6th of April this year, anyone who holds a biometric residence permit, a biometric residence card, or has been granted status under the EU settlement scheme, so that's anyone, any migrant from the rest of the world effectively, you can only do online checks for them using that employer checking service. So it's worth getting to grips with that now while you can and having a look at that. So you'll not be able to accept physical cards or evidence, and you won't have a statutory excuse against employing somebody if you do it that way. So that's a really important change just to be mindful of. And then we've also got, oh sorry Eve, just a little bit ahead of myself. We've also got some changes coming as well for British and Irish citizens, even those who hold British and Irish passports. So there is going to be enabling legislation from the 5th of April 2022 to enable employers to use identity or identification document validation technology, a bit of a mouthful, IDVT, and to use identity service providers to do these digital checks online for you. This is a really big change, and we don't know much about the detail or how it's going to work, but we are promised this enabling legislation to enable this to start to happen from the 5th of April. Obviously, there'll be a time delay while we get up to speed, and the government want really to link this up to right to work checks and disclosure and borrowing checks as well, to bring it all together and make it easier to do these checks. So there will be enabling legislation for this to be in place, but it's going to take a little bit longer for this all to be ironed out. And very importantly, even if you do decide to go down the route of asking identity service providers to do these checks for you, it is still your responsibility as the employer to make sure that those checks are done correctly and in line with the prescribed guidance. So there's a lot of detail there to be ironed out, a lot of guidance which is going to follow. We'll keep you updated on that. But one to watch, because that could revolutionise how we do our right to work checks. But obviously, it feels obvious there's going to be some kind of cost there for those identity service providers to offer that service. So it might not be one that you want to go down the road of. Thanks, Eve. Sorry, the next slide now, please. So what should you all be thinking about now? Right to work checks should be right at the top of your agenda. We've got so many more people now who need evidence that they've got the right to work. So you need to be making sure that you are checking correctly and that you aren't inadvertently employing illegal workers. Make sure anyone who's involved in your recruitment processes is trained and understands these changes and is doing it properly before they start work. Keeping up to date is really important. And in the slideshow shortly, you can sign up to our e-news. We regularly send out updates about changes that are coming and things you need to be aware of. But also the gov.uk website is really helpful. You can flag up there for updates. I know Eve and Rich and the Chamber do lots of really useful updates as well. With the gov.uk website, you can, if you're super keen, ask to be updated daily. I wouldn't recommend that because you will just be inundated, but it might be just a monthly update could be quite helpful to keep you up to date and just make sure you understand what's going on. Have a look at your workforce, think about your recruitment need in the future, and if it makes sense, apply to become a sponsor now. That's going to shave off so much more time of the process when you have identified somebody that you want to move to recruit quickly, and it just makes it a little bit easier. So thinking about, have you got a skill shortage? If you are already a licensed sponsor, think about, have we got enough undefined COSs or do we want to ask for more? Have we identified that we've got a pool of people that we need to do certain jobs that we can't recruit internally? Fine, let's ask UKVI now for those pool of COSs to shave off potentially 4 weeks of that process as well. Have a look at your practicalities for managing your own visas for anyone who might be here on a time limited basis. Make sure internally that that works, and logistically you haven't got somebody who's going to go off on holiday for 2 weeks and you're going to miss somebody who then becomes an illegal worker. Make sure that all works. And think about your budget, your financial budget, but also your time budget, because as I've demonstrated through the sponsorship process, it's not something, unfortunately, that you can do particularly quickly. So factor that into your decision making, and that's really important to think about. As I mentioned as well, if you've got evidence of low skilled work that you're absolutely desperately struggling but failing to fill, let Eve and Rich at the Chamber know so that we can push on that to try and get some support and try and make some changes. And if there's anything that I can help with, you've got my details, please do feel free to get in touch. I'm always happy to have a chat and to give a steer. Thanks, Eve. So we've rattled through quite a lot quickly this morning. I don't know, is it worth, do we want to end the recording there, Eve, and then we can open the floor for any questions?